So let's just say a few things about this Lord Hanningfield case, and this matter to do with the expenses scandal, which sort of arose in 2009, and I didn't really know about at the time. The Lord Hanningfield, his particular case was concluded in, I think it was 2017. Actually, is this 2017? I'm not sure it says on there. I think it was 2017. But it was 2009, 10, 11, 12, 13, 14, 15, 16, 17. So that was 8 years after the newspaper investigated it and raised the issue. And apparently Lord Hanningfield and some other House of Lords members did some prison time. But that is against the privileges of Parliament, really, for them to be arrested or put in prison when they're peers, particularly during the time of Parliament, although they can be put in prison in between that time, or they can be put in prison by the House of Lords itself. But this is the issue to do with, I think that there's more to this story than on the surface. I think that the newspapers have colluded with contacts within Parliament who wanted to further diminish privileges and bring about a new paradigm, an interpretation of privileges whereby MPs and Lords can be arrested for crimes during Parliament, and help to promote that because they did it, right? Later on, Hanningfield claimed privileges, but the whole thing is completely and totally wrong on several bases, and I want to try and explain what really the law is and should be about this. Here's Patrick Gibbs, KC. He represented the Crown Prosecution Service, so he was acting as prosecutor. Here's a picture of him walking up the road. Here's him acting now. He's acting as a defence lawyer. So this guy's switching sides, 1 minute he's acting as a defence lawyer, then he's prosecuting for the CPS. So he's basically like a bounty hunter for hire, right? This Gibbs guy. Here we have the original story, right? It was the Daily Telegraph was the newspaper, so it wasn't the Sun. It was the Daily Telegraph who first publicly exposed the MP's expenses scandal in May 2009. And what they did is they did investigative journalism. They simply used the Freedom of Information Act, but I don't know where they got the tip-off from, right? And they got this information from the government using the Act, but then they published it, right? So it seems like by publishing it, that's accusing someone of a crime. I don't know if they can do that without it being proved, because I know that a lot of people accuse people of certain things, but obviously they had the evidence to back it up. Now, I think this is illegal and wrong on a number of reasons. Firstly, right, even though it was a Freedom of Information Act and it was information they could ask for, by the end of the case, Hanningfield had proved that his accounts and expenses and things like that were privileged and they couldn't be heard in the court as evidence, right? Because it was matters for Parliament. Now, if that was correct, if that legal basis was correct, and if Jeremy Johnson, in fact, hold on a minute. Right, so here's Jeremy Johnson, right? This is Jeremy Johnson QC, now Jeremy Johnson KC. He was the barrister for Hanningfield, right? Acting on behalf of Hanningfield and the House of Lords. He actually was rewarded and given a place as a High Court judge following representing Hanningfield. So he was rewarded by being made a High Court judge, right? Now, his basis was simply... It's 6 pages, right? It's a 6-page paper. It's got citations of Erskine May, but it doesn't cite the Parliamentary Privileges Act. It gives a few case study citations, but it primarily relies on the 1688 Bill of Rights, Article 9, right? Which is often misquoted in the Parliament reports, in the privilege reports. In the committee reports, it's often misquoted. Now, they use Article 9 and they say that Parliament can judge its own affairs and matters, and if they raise matters of the House of Lords in the court, it would be touching on their matters, so they can't do it, right? Now, so that's how we claim the privileges. But they claim the point is that they prove privileges, right? The judge, Alistair McReef, he said, okay, right, the order was that it was privileged, right? Now, immediately, in a court, someone has brought a prosecution against Hanningfield that is privileged, and it is being admitted and ordered by the court, whether or not we agree with that or not, and whether or not I think that it's wrong or not. It was ordered by the court, so it was ordered by the court, not by Johnson, by McReef. We could get Alistair McReef's photo up, right? It was ordered by the court that Hanningfield was privileged. Now, that means that Patrick Gibbs KC, right, had been prosecuting illegally against Hanningfield. And that's a contempt of Parliament. So, and the Crown Prosecution Service who handled the case, and obviously the police who arrested him. Now, that is a contempt. So now it might not have been for Alistair McReef to prosecute for contempt, but it at least should have been acknowledged. They should have known that breach of privilege is contempt, right? And Alistair McReef could have sent a report to Parliament, to the Speaker, because, in election petitions, or usually when there's a Parliament, I think when MPs get prosecuted, the judge has to send a report to the Speaker of Parliament anyway, right? When an MP gets prosecuted, because it's all to do with that Recall Act 2015. Also in the election petition proceedings, right? Now, that means that Alistair McReef really should have sent a report to Parliament. Some sort of machinery was meant to happen, right, when that privileges order was claimed. Now, in the... I've just been reading the Parliament reports, committee reports on privilege, and they say that they claim that the government has never known an instance on record where privilege has been used to evade criminal proceeding or protect against it, which is complete utter tosh. Hanningfield's case definitely is one of those instances where that is true. And in most cases in the history of England, when they use a writ of privilege, what it did is it protected them for a duration of time, and then they got prosecuted later on. So it's kind of like a postponement in a way, and they wouldn't have really had records of it, because I think that they send all the writs out, so they don't keep copies of them. All these letters are sent out, and it just postpones it, and they still get prosecuted. It basically moves the date to when they get prosecuted, right? But the thing is, if someone is prosecuted when they're privileged, it's meant to be contempt, right? Now, Alistair McReef was really supposed to do something at that point. Now, Jeremy Johnson KC did not raise that issue of the contempt or mention it at all. It was up for the judge to recognise that. It was up to Alistair McReef to recognise that, right? Now, therefore, I don't know if the court can... I don't think the court should have prosecuted Gibbs for contempt, because it's a contempt of Parliament. But I think what McReef should have done, because Lord Hanningfield was a member of Parliament anyway, he should have sent a report to the House of Lords or something like that. And the House of Lords really should have prosecuted Patrick Gibbs KC for contempt, and the Crown Prosecution Service, all of their solicitors who dealt with the case and acted to bring the proceedings, and possibly even the police who arrested Hanningfield, right? Either you're claiming privileges or you aren't, right? And this is what the section in parliamentary practice is contempts against petitioners and others soliciting business before either house. So this is an instance where it did happen. It was proved in a court. So the order was made that he was privileged, and they clearly had been prosecuting him illegally, right? So Gibbs has magically escaped contempt and the Crown Prosecution Service, and this is why this is the rare case of when it actually does get proved, and they're still evading the contempt. Right now, this is why the police and the CPS, when the CPS was formed in 1985. And they brought this Public Order Act in, and the Tumultuous Petitioning Act was withdrawn, and you've got all these proceedings where the Attorney General's meant to check people for political objects and so forth. It's all tied into that, and the police don't really want to be the ones who are being prosecuted. The police, we do the job. We're the ones who get the bad guys, right? We do the prosecutions. We don't get prosecuted. Now, they do occasionally when, people go and, actions against the police. But a lot of those people who are doing actions against the police aren't even doing the law properly, because if you've been prosecuted by the seal of a judge and by the warrant of a police officer, you're under seal, right? And you've got 12 years to claim. But a lot of these companies are only companies who previously were dealing with like trips on a pavement or things like that, which is normal tort, or Mr. Smith owes me £5 or whatever, or the plumber, I don't know, just normal tort cases. But when you start getting into policies, contracts and agreements, it's meant to be 12 years. And this is the scam that they're doing in a lot of corporate companies with policies. They're saying, we can only claim within a certain amount of time. When in English law, if you're under an agreement, that's the whole point. The law is that because it is an agreement, you got 12 years to claim. But a lot of these agreements are saying that, we're only giving, a certain amount of time to claim, or if they give an automatic warranty that is within a certain time, which they'll do anyway without going to court, fair enough. But, when they're starting to say that, you will not, you will not make any claims against us or anything like that, you can't really have that agreement because it's taken away a fundamental law of England, really. But that's a completely different matter. But some of these claims against the police companies are doing it wrong. I've noticed now that more of them are doing it, and I don't think that they're necessarily doing that maliciously, but they could be. But I think it's because they're just inexperienced and they've got a certain way of doing things with other claims, and they just think that it's the same when it's not, and they didn't really realise, unless it's concerted. I think it might be a little bit of both, probably less concerted. The type of companies who are doing it, like, this Satchel Moran's and this Copper or whatever it's called in Manchester, I think could be concerted, but this is when you get into, like, these election laws which are being flaunted and stuff like that. There's a lot of misdirection from the legal sector at the top. Particularly, like, when it was that spitting image programme and things like that, when it was clearly promoting Margaret Thatcher, making her more popular. But anyway, these are other side issues that keep arising while I'm talking about this. So, if I can go back to Gibbs, right? Gibbs evaded contempt, but so did the Crown Prosecution Service, the unit, and so did the police, right? Because, the Crown Prosecution Service doesn't want to be criminals or be accused of being criminals, even when it's proved in a courtroom and reported on that, Hanningfield was privileged, right? So this is how they're getting away with it. So anyway, coming back to this story, right? So this is just how the CPS and police are evading contempt, even when it's proved, right? In broad daylight, in complete and total broad daylight. And who's involved in that is, these top barristers, lords, and now High Court judges. Johnson even gets promoted to be a High Court judge, right? Yet he didn't prove. Now, if you're a member of the House of Lords, right, if you are a lord, right, and someone prosecutes you illegally, and it's proved, why wouldn't you want them to face contempt charges? It means that you don't really want the law properly following through or being enforced. But yeah, they got him in prison, and they're trying to prosecute him again, and they really want to, convict him, but he doesn't want them to be prosecuted or convicted of their contempts, right? But should Hanningfield have even been in court in the first place? Now, this is the thing, right? If they proved in the court session that those matters of Parliament were privileged and couldn't be used in a court, right, then how could the Daily Telegraph have legally put them in the newspaper and accused them of an offence if it was privileged to Parliament, right? How is it that they're under freedom of information? Because in Jeremy Johnson's paper, he never proposed that, oh, well, clearly this is not privileged to Parliament, this evidence, or else how could the newspaper have published it, right? And put it out there in the first place. You know, how come it qualified as freedom of information, right? You know, but oh no, it can't be used, right? Now, this is the thing. Now, information that is available to the public that Parliament show on their websites, any of that information can be used. And it's privileged for us, right? And anything that Parliament publishes. Now, this is for the Parliamentary Papers Act, right? The Parliamentary Papers Act protects newspapers and us, petitioners, and anyone who uses any published information by Parliament, or really anything that's for the purpose of Parliament. Now, this is the thing, right? This is my opinion. If the newspaper, did use freedom of information or otherwise investigated Hanningfield and they thought he'd committed an offence, why didn't they just report it to the police? You know, they're a big newspaper. They've got a lot of staff who could put multiple complaints into the police. They can contact the CPS. The newspaper have got their own lawyers who are on full time, these night lawyers, who could write up a very compelling criminal report to the police, like a prosecution standard level report to the police, to log a crime, which would make them investigate it, right? Why do they need to put it in the newspaper? Why do they need to make an exhibition and spectacle out of it first to put pressure on the police or the government to act? They wanted actually to make it publicly known and show off about it, right? Well, how can they do that? Well, supposedly, if they did get a freedom of information request and that was therefore issued from Parliament in a parliamentary paper, then they can publish that and it's privileged, right? But privileged to share and publish by the newspaper that can't be prosecuted against. And so therefore, why couldn't the court use it, right? Because it been published, once it's been issued in a freedom of information, it's been issued to the public, right, as information. So it's been released to the public. So how could the court say that you can't use it? Now, this is the thing. I think that if the newspaper just wanted to get action against Hanningfield, right, why didn't they just report it to the police, right? And then after they'd started the investigation and he'd been charged, then put it in the newspaper, right? And show off about it. But this is the thing. You're not really meant to say too much about legal cases in the newspaper anyway, right? Particularly while they're ongoing. Now, this is my opinion since reading the privileges, because, Jeremy Johnson never used the Parliamentary Privileges Act at all in his paper, right? Because they've got specific laws in them. Now, according to those acts, it says that you can recover the king's debt, right? So if you owe the king money, which is like His Majesty's government, right? If you owe the government money, right, they can recover that money through legal proceedings, right? You can't use privilege to get out of it. So that means that Lord Hanningfield, they could have, if he owed money, right, there's nothing to stop proceedings being brought against him to recover that money into, obviously, if you're going to bring a civil suit against Hanningfield for the king's debt for money, then it's obviously going to be an investigation, a civil one, to find out whether he does owe the money or not and whether he did cheat on it. And then if he owes the money, then you claim the money and you claim it back to the government, right? And then he pays it back. And once you've done that, what you've actually done is you prove that he did break some kind of rule and he did owe some sort of money, right? And then you get him to pay it back. Now, that is, he can't be arrested for that, but now Now, this is where there's some issues over the parliamentary privileges, because you're not supposed to be able to bring summary proceedings during Parliament sessions. You're meant to bring them in between Parliament sessions, right? Now, traditionally, they could bring in a court of record, which the High Court is a court of record. You're meant that you could start proceedings, start court cases during Parliament, but members weren't arrested, right, or imprisoned. Now, the government got rid of and abolished felonies. They scrapped felony, and also a magistrate's court is not a court of record. It has to be a court of record. So, but the High Court is a court of record. So you could have civil proceedings in the High Court against Hanningfield. Does he or does he not owe money? With an accompanying investigation, and if he does owe it, then pay it back. Now, wouldn't the newspaper be satisfied with that, right? Now, if the case did investigate that, it cannot be privileged, because it says that you can't use privileges to evade the king's debt, right? Now, that would have cleared up the issue. Now, if the newspaper would have wanted to still, they think that Hanningfield should have somehow been prosecuted criminally, in between the sessions of Parliament, they could prosecute Hanningfield criminally, right? And they could get a conviction against him, right? Not in a magistrate's court. I don't think it should be a magistrate's court. In a court of record, it can start outside of Parliament time. But whatever, it doesn't matter what time it is, really, because, there is a time when you can do it, right? And if they'd have had the evidence from the civil case, which proved what happened and what wasn't, what was done or owed, mainly the criminal charges, was there an intent behind it? Does it make it criminal as well? If they'd have done the civil case and recovered the money, which can't be protected with privilege, then most of the work would have been done, and they would have to get his intention of himself, right? Which, was all to do with his person and not Parliament, right? So, and this is the thing, though, but the Lords still, when they're working, as long as they're Lords, they're not meant to be able to be put in prison by the courts, right? Or fined by the, arrested. So Hanningfield never should have gone to prison, and they never should have been arrested. Now, my hunch on this is that the whole of the establishment of Parliament kind of really wants to scrap privileges eventually and get rid of them, right? And this is part of it. They've got that Recall of MPs Act, which you can still use that act on the ancient privileges basis, because they can still get prosecuted in between the session. You just have to wait until between the session, right? And then you can still have a recall of an MP and use that procedure, okay? And the election petitions is a little bit different, because that used to be preserved for Parliament. You see, that Article 9 of the Bill of Rights, what says that, matters decidable, cognisable only by Parliament, that was when election petitions were also only heard by Parliament as well. They were only matters reserved from Parliament, but they opened it up to the courts now. So when Jeremy Johnson is going by that Article 9, he's totally off the page, off the 6 pages. That, well, what about election petitions? They were matters only reserved for Parliament. I've got 4 books here, absolutely ram stuff with election petitions being heard in Parliament, right? But after 1868, they said, the courts can hear it, right? So Article 9 can't have been that... They kind of wanted to protect Article 9 that much, because they wouldn't have allowed the courts to read those election petitions, right? But now it costs you £5,000 to bring them, right? And they can hear matters to do with Parliament. You got to answer questions. You can't use privilege for it, right? So really, but that matter to do with the king's debt, right? Didn't protect from it. You might say, well, this civil arrest and Mesny process thing, it means that they still can arrest you for criminal things, not for civil. But let's get this clear, right? That the abolishment of arrest on civil Mesny process was put through the mid-1800s, right? Around 1830s, 40s, 50s, around the time of the Parliamentary Papers Act, right? in Erskine May's book, in the Sir Barnet Cox edition, and in the Gilbert Campion edition of Parliamentary Practice, this is when he's putting that contempt against petitioners, right? Because that wasn't in the earlier versions. He's put Gilbert Campion and Cox have put that misconduct against petitioners in. It was quite a late and new addition to the Parliamentary Practice book, right? If you completely and totally abolished arrest on civil process, right? So no one's getting arrested on civil process in the whole country, then why would you publish and introduce a brand new section into Parliamentary Practice in the 1964 and 1946, right? In the mid-1900s, making a big importance about, petitioners can't be arrested, or people in parliamentary business can't be arrested, right? If they'd already, why would you do that, right? If no one was arrested anyway, right? If no one in England is arrested for civil processes, right? Why, and it's just not done at all, why would you put it in the Parliamentary Practice book, right? In 1964, to say that this is a contempt and you can't do it? It would be a bit pointless unless they're using the term arrest on civil mesne process to mean that you are engaged in a mesne civil process, right? You are conducting a mesne civil process, which means that you are busy doing something which is protected and you can't be arrested, right? Not the fact that people can't go around arresting people because they owe them £5, right? We're talking about, people bringing civil processes aren't allowed to arrest other people. That wasn't done in the 1800s. From then onwards. So what's the point in putting it into the Parliamentary Practice book to say you can't arrest people if you're bringing a civil claim, right? When, they stopped doing that ages ago. So what's the point in the page, right? Unless it also means that while you're engaged in a civil process, while you're conducting a civil process, while you're executing a civil process, right? Because abolishment of arrest on mesne civil process means also that I can't arrest someone because they owe me £5 because I'm bringing a civil process, but also when someone's engaged in a civil process, they can't be arrested. No one can be arrested for bringing or doing a mesne civil process, which means that it's not just that, I can't have John Smith arrested by the police because he owes me £50 and I'm bringing a civil case. We don't do that anymore, right? But also, I'm conducting a civil process and I've got a right to, execute this proceedings to completion without intervention, right? It's like, it's a poetic meaning to it on all levels, right? Now, it must mean that it has to, or else there's not really any point in Gilbert Campion and Cox putting it in the Parliamentary Practice book when they completely and totally abolished anyone arresting anyone for bringing a civil suit, right? To me, it would be pointless. Because that whole hatchet's dead and buried. No one arrests anyone when they're bringing a civil process, so including Parliament, right? So it cannot mean, I'm going to, I'm going to arrest Jeremy Corbyn, right? Because he owes me £10, but he's an MP, But if no one can arrest anyone when they owe you £10, then it doesn't matter whether it is Jeremy Corbyn or not, or whether it is Joe Bloggs, because I still can't arrest them. So if I can't arrest anyone because they owe me £10, and the police don't arrest anyone because I owe them £10, right? Since the 1800s, doesn't matter whether they're an MP or not, why would I be arresting someone and need to be warned about, oh, you better not arrest Jeremy Corbyn because it's a contempt? In the parliamentary practice book, in the 1964 book, right? Why would it be in there? Because no one arrests anyone if they owe them £10, let alone whether an MP or the Scarlet Pimpernel. So it would be pointless having it in there because they just don't do it anyway at that point. Now, if you want to, so it's an additional contempt, right? But it must be in there. But what's the point in having a section saying that you can't arrest petitioners? Okay? Because no one arrests anyone for civil process. It doesn't matter whether they're a petitioner or not, because no one arrests anyone for bringing a civil suit. So why does, 100 years later, after 1850s, 1830s, right, in the 1930s, 40s and 50s, what is the point of having a section, misconduct against petitioners, arrest on civil process, right, if no one arrests anyone on civil process for the last 100 years? It has to be protecting the petitioner themselves and the MPs. That the process cannot be intervened in. It has to be that parliamentary procedures are the civil process, the High Court of Parliament. It has to be that the petitioning processes are the canvassing, the advertising, the collection of the signatures are the processes. It has to be, right? But you can bring a suit in a high court as long as you don't arrest them or put them in prison, right? Which is where the protection is. So for Hanningfield, if there was evidence that Hanningfield owed the government money and he'd been fraudulently claiming expenses, then, but the thing is, the police don't the police do not take people to court. This is the thing. The police now do not take people to court unless it's criminal. So the newspaper might have evidence, right, that, Lord Hanningfield has been cheating his expenses, right? So why don't they take him to high court? Why didn't the newspaper take him to the High Court? Oh, because they've got to pay for it. Oh, what a shame. A multi-billion-pound newspaper has got to pay. We've got all this evidence against Hanningfield, right? But we're not paying for it. We're claiming that he did his expenses, but we're not going to pay for take him to the High Court to prove it and make him pay it back. We want the taxpayer, right, to pay for the police, right, and the CPS to criminally prosecute him, right? We want the taxpayer to pay for it. Oh, and by the way, what about the £5,000 election petition fee? Are the newspaper going to pay for that to challenge some of these seats in Parliament? Or are we going to get the police to pay for it, right? Mainly when the newspaper has been promoting and making these MPs popular or unpopular, and now GB News is doing, and all of these newspapers have been contributing towards the popularity or unpopularity of MPs, particularly maybe even helping and aiding them getting investigated. Who's going to put up the money to take the newspapers to the High Court, right? Because the police aren't going to do it. And who's going to widely publish it in the newspapers and promote the evidence against the newspapers? Not the newspapers, right? So if I want to put my evidence against election crimes and raise the awareness of it so it compels the police to act, it ain't going to happen in the newspaper because the newspaper aren't going to widely publicised stories that they've engaged in the corruption, right? And when I want to put an advertisement in the newspaper, they might say they're not going to publish it. And if I want to petition about it, then they're charging me VAT on that as well when I'm not supposed to pay VAT. What about the newspaper's expenses? How about the newspaper's expenses scandal? The London Evening Standard VAT scandal, making petitioners pay VAT up front on petition adverts in the newspapers. That's an expensive type of expensive scandal, right? And Jim Harrow's gone now. Poof, he's gone. They got a new guy in charge of Revenue and Customs, right? Who's going to widely publicise the story that the newspapers have been scamming us on VAT, let alone Hanningfield, right? And what is it going to take to get the police to act? Now, I don't think that the police should or could have acted against Hanningfield, at least not during the sessions of Parliament time. I think the police could have prosecuted Lord Hanningfield in between the sessions, and they could have got him criminally then, but he would never have been arrested or gone to prison during Parliament time, because that's what the privilege is meant to be, unless Parliament, the House of Lords, wanted to put him in prison, which is different from the courts, or if they wanted to, So, now, this is the thing. The newspaper really should have pushed for a civil charge against Hanningfield, but who's going to do it? Because, if the police don't do it criminally, I mean, who brings civil proceedings? Some government departments, if you haven't paid your taxes, right, Revenue and Customs can, fine you and take you to court. It's a little bit like a parking ticket. It's not a crime, but they want money from you, right? There are civil processes of government departments. So the newspaper, the Daily Telegraph, really could have, with all their influence, Revenue and Customs to bring civil proceedings against Hanningfield, right? Which could have been done. And if they'd have succeeded in that, they'd have got the money back, and it would have helped to prove that he committed the crime later. But he should not have been arrested or put in prison, not during Parliament session time. That's what lends me to think that there's a lot more to this than just expenses. It's a whole entire, the 2015 Recall of MPs Act and all that flavour of movement. They're wanting to try and reinterpret privileges to mean that MPs can be arrested during Parliament time when they can't, not unless it's a court of... they cannot be arrested. The Parliamentary Privileges Act say that they cannot be arrested during the time of Parliament, right? Mike Amesbury, Dan Norris, and Patrick Spence, they are to be dealt with after the sessions, right? And that's just what the law is. So with the Hanningfield thing, you see, the Crown Court was a court of record. So really... They could have prosecuted him in a court of record during Parliament time. But the thing is, they abolished that felony as well, which is to be treated as a misdemeanour. So if it's suddenly to be regarded as a misdemeanour, it's to be regarded as summary, which is... That's another major cock-up which the government sort of did without really thinking properly about it, when there's a much wider system in effect. So... Now, I don't think that the newspaper should have been publicising, popularising accusations against members of Parliament, because that again is defamatory, really. But then again, they obtained it through a Freedom of Information Act, and if it's a Freedom of Information Act from Parliament, it is a parliamentary paper, so the newspapers kind of were privileged, but they were using it to kind of affect the reputation of a member, right? Which that's a contempt in itself, because really Hanningfield should have had a fair trial, because what they're doing is, what the newspaper was doing was appealing to the common people, to the not to the parliamentary peerage, but to the public peerage, the common peerage of the country. They were appealing to them and saying, look, this guy's a criminal, right? And they were wanting to make the whole country have an opinion one way or the other against him, which if it was an MP, if he hadn't been prosecuted, really, that affects him in the election when he hasn't been convicted by a jury in a court. Now, what I think the newspaper are doing, right? What the newspaper really are doing is they got information from Parliament, and it's official. It got released, and that's parliamentary privilege information if it's for a parliamentary freedom of information request. And what they did is they put it in the newspaper and publicised it, so they wanted a public opinion on it. They didn't, prosecute it in a civil or criminal case. And they wanted to get a response or reaction from the government, really. That's petitioning the government. So immediately the newspapers are really taking it to the parliament, really. And at that level, they're not really pursuing a civil case themselves in the courts, and they're not really, bringing criminal prosecution. They've actually raised it to Parliament, a parliamentary matter of a lord or peer, and it's almost like they're wanting, what are they wanting from the public? They want the public all to sign a petition to get action, or general disgruntledness, grievance. This is the thing. What's the point in the Michael Westwood petition to Parliament? Really, the newspaper, they're wanting to raise it to a higher level than just get a barrister, get the evidence, go to the High Court, and get an order against Hanningfield. They're wanting to create a sensation, a popularisation. They're wanting to get the whole public behind something, which is what you're doing when you do that. You are raising it out of the court and above and beyond the court, both criminal and civil, to the Parliament for a resolution, really, because that's the whole point of informing all citizens to become, in effect, the grand jury, right? Or the petitioners, which is like with the Michael Westwood petition. But they didn't. Instead, they went in these proceedings, and this is what those proceedings are meant to be protected about, too much information going to the public. So they're pissing all of these. What these newspapers are doing is filling a bag with piss, and they're just puncturing it, and just piss going everywhere, right? Almost a little bit like the Stonehenge case. It was petitioned to Parliament, taken to Parliament, and it's meant to be an actual proceedings and procedure, really. So I think the newspapers really want to have their cake and eat it. They want everything. They want, petition signing, a resolution from Parliament, they're trying for, but at the same time they want criminal proceedings with the Crown Prosecution Service in a normal court. They need to make their minds up. And I actually think that I do think that it could have been done criminally. But they went for all these arrests and imprisonments and all these other things. Apparently the Lords tried their privileges the first time around, earlier on, after 2009, but it didn't work. And it was only later on when Hanningfield did this privileges stunt. Later on, Hanningfield does this privileges stunt, 2017, using the Bill of Rights, but I can't see how Article 9 is matters that can only be decidable by Parliament, right? But they've already got and obtained the information and put it out to the public, and apparently that's parliamentary privilege information that can't be prosecuted against, right? So if that's parliamentary information which can be used by a newspaper and no one can take a civil or criminal charge against the use of that information, right? How could, on the basis of the Parliamentary Papers Act, that freedom of information request really being issued from Parliament, being a parliamentary paper, how could they have used it in court anyway? Right? Because what's the point in Jeremy Johnson Casey's 6-page paper? And how much did he get paid for that paper? And then promoted to a judge when he proved in that paper, hey, this is like privilege of Parliament, this information, and Hanningfield can't answer questions, when the information that the newspaper got from Parliament is a parliamentary paper and is protected against, the information itself is protected against civil or criminal proceedings, which could have just been used the Parliamentary Papers Act itself. And you wouldn't have even needed to pay Johnson a penny for that representation, because the Speaker of Parliament should have done a writ or issued a writ through the Parliamentary Papers Act, which is what they updated it to in 2005, right? So the Lord Speaker could issue it. Why didn't they do that with the Lord Speaker? Why didn't the Lord Speaker say, hey, that information that the newspaper got, by the way, all those figures, that's parliamentary paper, right? You can't use it for civil or criminal proceedings, right? But that kind of solves the Jeremy Johnson claim before he even did his own claim, right? Without even needing his claim. But why, but the thing is that, why was he arrested and put in prison in the first place and during session time? And why didn't the newspaper, if the newspaper was so passionate about wanting to get those MPs all prosecuted, why didn't they, they're a multi-billion pound company, why didn't they, take them to the High Court? Or why didn't they, why didn't they get the High Court? Because remember, so if that Freedom of Information document is a parliamentary paper, which is issued from Parliament on request of expenses of Hanningfield information, right? Remember, the Parliamentary Privileges Act say that you can't use a privilege to protect against a civil debt. So, to the King. So they couldn't have used privileges to protect against recovering that money through a civil process, right? Only really against the arrest and imprisonment during Parliament time for criminal. But ironically, the Parliamentary Papers Act 1840 isn't to be regarded as affecting a parliamentary privilege. So it's kind of been enacted as a common law, not really as parliamentary privilege, although it can be used to help to claim and enforce it. That Parliamentary Papers Act says that you can be protected against criminal or civil proceedings for information that is issued by Parliament, but it's not to affect privileges either way. Now, on that basis, and this is actually a superior legal claim than Jeremy Johnson's 6 pages, on that basis, the Lord Speaker could have issued a document, or Simon Burton, the Clerk of the Parliament, although I don't know if it was Simon Burton back then, could have issued the Parliamentary Papers Act claim to protect Hanningfield against the use of that Freedom of Information Act information, right? And it wouldn't necessarily have to be privileges. But would the Lord Speaker do that? Would he want to do it? This is the thing. But to me, that stems right back from the newspaper getting the information and then themselves, because the newspaper, if the newspaper published that freedom of information, right? Just consider it this way, right? When the Daily Telegraph published that information that they acquired from the government, officially released, right, made available to the public, if you or me would have prosecuted the newspaper for putting that, they might have used that Parliamentary Papers Act themselves and said, oh, no, you can't prosecute us. This is a parliamentary document. This is a parliamentary paper. It's a freedom of information from the government, right? You can't prosecute us for publishing it, right? You can't prosecute us for its usage, right? So and this is the thing where the newspapers are a bit retarded and stupid. So, but that is exactly the same instance as Hanningfield, as far as I'm concerned, as far as I think. You can't prosecute the newspaper for publishing it for criminal or civil. So why Hanningfield? Not criminal, but you can still recover the King's debt. But the newspaper didn't want to put up the money for it. A High Court case. The High Court could have asked for donations. They could have said, they've got millions of subscribers. Put some money in the pot. They could have said to the public, we want to prosecute them, send some money, and they could have raised the money like that, right, and done it. Or they could have put pressure on, if they're petitioning the government. You see, what they're really doing when they put all that information in the newspaper and they're saying, yeah, let's get the crowds behind it, let's get the people behind it. Let's get the population supporting this, you know, and all rattling the cages and, you know, like grumbling to the government. It should have compelled HM Revenue and Customs to bring the civil proceeding against Hanningfield to recover the money, right? And then it's not us that, well, you know, and then that would have done it. But if I was acting as Hanningfield's lawyer to defend him in that instance, which I think that should have been what happened. You know, the newspaper should have compelled HM Customs, you know, to bring action. You know, they're removing these refugees and things like that, driving around in vans and doing all that kind of stuff, you know, things like that. And, you know, in defence of Hanningfield, I would have used the Parliamentary Papers Act, and I would have, instead of that 6-page paper from Jeremy Johnson, from this Moffat, from this Muffet, this little Mr. Muffet sat on a tuffet, right? He's been promoted to a High Court judge. You know, the excellence, the outstanding excellence of this individual. The you know, it's amazing that he won a legal contest. You know, or did he just win a literacy competition, you know, in English, arcane, peculiar English language that no one can understand, you know, because he can write fancy, right? You know, maybe he won a calligraphy competition or something, right? You know, but now apparently he's sitting in hearing cases in courts. So if I would have been defending Hanningfield, I would have used the Parliamentary Papers Act 1840, and I would have said to the Lord Speaker, you know, that's information that they're bringing charges on documents and information that were published in a newspaper, which are parliamentary papers and documents, right? So they can't use those in a court against me, you know, on a protection from these criminal charges, right? That really is more or less what Johnson's 6 pages was saying. But I don't agree with his papers because, you know, you've got, you know, matters, you know, we might touch on matters of Parliament in a court. Whoa, whoop-de-doo. What did they do with the election petitions? They said, courts can hear these matters of Parliament now. So it can't be that much of a big deal or issue, courts using information of Parliament, because they had this procedure as well prior to, I featured it on my Facebook page. It basically said that if you wanted to use any information or go on to matters concerning the House of Commons, you had to do a petition of leave from court, right? Which is kind of like, you know, if you were being prosecuted for like, you know, petitioning, that's matters of Parliament, because it's a case to Parliament they wanted to prosecute you for. So it would be that is one of the processes, a fail-safe process, which is supposed to really protect petitioners as well, in a way, right? But they got rid of that process, and apparently it was never really adhered to anyway, but not for the House of Lords. So that issue would not have been relevant to the House of Lords. I still think that, you know, this Article 9 business, there's a lot going on at the moment. There's a lot of naive and not really very, very educated MPs who are getting elected, and they're getting put on these committees, and they're doing these reports, and it's very corrupt. You know, you've got like Jacob Rees-Mogg being on like committee for e-petitions, going, oh well, yes, it's these people are absolutely protected by the 1688 Bill of Rights, but wouldn't it be nice if we could control that or restrict it somehow? Even though to plan to do such would be contempt. So, you know, these committee reports are not always very accurate. And the people who are on these committees, unfortunately, the standard is getting lowered and diminishing until we've got to a point where there are some people who are just not competent, but there are other sharks on there who are more savvy, like Tony Blair, people like that, who really, when he invented e-petitions with number 10 and so forth, and now you've got Jamie Stone on the petitions committee, you've got all these blockage procedures they're doing. We can't let you share it until we've approved it, and you can't enter into any debate or dispute about it, with the staff on the petitions committee. They're just rejecting all these things, and there's a lot of obstructions being put up which are not lawful and which are out of the process of, they're out of order of proceedings. And Tony Blair really is an instigator of that. But also Tony Blair has, done this illegal attorney generals being barons and peers while they're serving. And also him doing all this, I don't know if Starmer wants to blame Margaret Thatcher, but I think it was mainly Tony Blair who's setting up all these, sentencing guidelines, and if you confess, you get reduced sentences and all this, which is going into the area of the conscience of the person. You can't go to a jury, you can't do deals with a jury to tell them, how they are supposed to return their verdict, because that is the conscience of persons, right? But all these laws now are just being totally scrapped, mainly because of, you get certain people who get into government who want to completely and totally change the system, but in doing so, you end up breaking it, and it becomes contradictory, and it doesn't really work properly. You can pretend it's working, but things are not right, because when you break a machine part, a physical machine part, it physically won't work, right? The problem with ideas and law and governance is that law and governance and writing is not a cog. It's not a piece of wood. It's not a piece of metal. It's not a piece of plastic. It exists in writing on a page, and, if all humans turned into, pigs or cows, we couldn't read it, right? It's just paper. You could chew on it and eat it, but that's about it. Ideological artifacts only exist in the human mind, and only interpreted by the human mind. So it's pure thought, right? And this is how, Keir Starmer and people in government can pretend that, laws don't exist, or can ignore them, or say they don't mean this or that, because there isn't an immediate breakage. If you suddenly start doing something completely wrong or different to what is written down, you can pretend that you're right, or convince people that you're right, and because it's only in the mind and in thought, there isn't an immediate structural seizure of the instruments, right? The car wheel doesn't come off, or whatever. What happens is that people recognise that it is wrong, or it is a lie or not right, and they call you out on it. And it's their opposition to it and objection to what's happening, which is the resistance, and at the end of the day, it's only like the Emperor's New Clothes, Keir Starmer can dance and sing in the street. Keir Starmer could dance down the road, singing. There's no such thing as a contempt, there's no such thing as a contempt. Keir Starmer could dance with, Patrick Gibbs down the road. They could dance holding hands down the road, like the Elves and the Shoemakers singing, "There's no such thing as contempt, there's no such thing as contempt," like this, dancing down the road. But yet, Gibbs prosecuted Hanningfield, and it was ordered by McCreef that was illegal. There was illegal prosecution there, it was privileged, so that's a contempt. So this is it, that they're pretending that, this is now where we are with Starmer and Gibbs, right? They're living in a fabricated fantasy dream world where the law is something that exists in the human mind, and that as long as they ignore it or pretend it's not there, they're okay. The law is like a tool, really, like a hammer or a screwdriver, or a saw or an instrument or whatever, right? in order to do anything or make anything, you need tools, right? Although your hands are tools, right? The law is a tool. If something is not illegal or if it doesn't exist in law, you can't really compel someone to do it psychologically, because in order to make them convinced to obey the law or to apply it, they need to understand it and believe in it, right? Unless you physically restrain them, because if there's no law, right, then you revert to physical force. It's gangs and warlords, right? If there's no written law or no stated law, then it's the law is in your own hands. To prevent someone stealing something, you actually have to use your hands, right? But with the written law, with the acknowledged law of the human mind, right, it exists, and it's all to do with obedience and compliance and other humans agreeing to do. The police can't enforce the law unless they, telephone other police to turn up, and they all use physical force at the end of the day, but only because they all know what the law is and what the law says, and they all consent to understanding what that is. And what politicians are doing now is they're making laws and they're enacting them, but really, after a while, they aren't particularly bothered or concerned about certain laws, or they want to break them, right? Like with these election laws, right? So it says that, privately funded enterprises cannot, give entertainment which is affecting the popularity of people in elections. That's the law. Now, at the moment, Nigel Farage is giving a big FU. He's giving a big middle finger. So is Tice and Lee Anderson and Esther McVeigh. They're like, we're going to be famous, right? We don't give a flying F what the law is. Like, we're not going to acknowledge you. Like, it's like walking down the road and someone saying, excuse me, do you know what time it is? And they absolutely blank you, right? We're going to blank this, right? We're going to pretend that we can't hear you, that it doesn't exist. There's no such thing. So it's complete and total absolute ignorance, right? They're running on ignorance. But hypocritically, they are wanting to get new laws made and enacted and wanting people to comply with them. Like, don't do this, don't do that. So it's like pick and mix. And you cannot take a person seriously, right? Like Keir Starmer, I'm very serious. This is the law. I'm in charge of the Crown Prosecution Service. These are documents. Things are written on them. I've got staff. I tell them what to do. It's a very important job. We're dealing with serious criminals here. It says here you're not allowed to do this. And I'm going into a very big room with important people. And you're a naughty boy. Yeah, and I acknowledge this. I support it. But, right, written down on another piece of paper by that government is a thing which you're not meant to do, right? But he does not want to acknowledge that it exists, right? Because he's not to his use. It's no use to him. He can't use it to stop someone doing something, right? And Starmer will not use it to stop Farage. Because, to be honest, that many people have been breaking that law that it compromised half of the Conservative Party. Look at Tracy Brabin. She was on Coronation Street. She stood for mayor and got elected to mayor, going on her popularity as a Coronation Street actress, a household name, every single day of the week on television with a psychologically implanted theme tune, na 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 na, psychologically implanted. Oh, we love Tracy Brabin, we love Tracy, all the women are going out from Labour voting for her, right? So it's, she would not have been voted in for West Yorkshire Mayor if she had not have been Tracy Brabin, the Coronation Street actress, right? So she got a pole position advantage over the other competitors. You know, and same with spitting image with Margaret Thatcher as well. And, you know, a lot of people didn't know about that law at the time. The government were misleading on it and the barristers. And now they decided to go full on, absolute full on. You know, Nigel, you know, there's Farage on there. He's got his name on there, Farage. I'm now a famous entertainer, household name. You know, got my own show. You know, now, if I ain't got him elected into Parliament, I don't know what has, right? You know, growing up as a kid, you know, obviously MPs are on TV. Once they've been elected, they've got the privilege of being invited on there because they were elected, right? But it's not meant to be what gets them in there in the first place, right? And that spitting image programme really wasn't supposed to popularise it. So, you know, Farage is full on, absolutely, completely, blatantly, full on breaking the law. And Keir Starmer is, how can you have any respect or integrity of being, you know, having any connection to the law or being a prosecutor at all? Whatsoever, when, you know, you're meant to be in charge of the government and these people are blatantly breaking the law, you know, and Labour really have done it with Tracy Brabin as an example. They're not as bad, but Boris Johnson was an entertainer. He was putting entertainment out in a newspaper column when he was Prime Minister, getting him elected, right? He's putting entertainment out there, entertaining people, and the newspaper was privately funded. The newspaper paid for the printing of it and gave him money, and they made him into an entertainer through a newspaper column, right? So, you know, these people, you know, what you know, they just want that law really not to exist anymore. But they haven't, you know. But that principle, it's been in effect for a long time. I would suggest that because, you know, the provision of the entertainment is illegal, right? I would suggest that, you know, they always had, you know, theatre, they had, you know, they had Shakespeare, they had quite a lot of plays and things like that. You see, I think some of these MPs really could have been, you know, if, let's say Shakespeare, right? If Shakespeare's got a theatre, he's got, you know, sets and props and actors, it's all set up. If Shakespeare would have got an audience together and paid for tickets, and then if they'd have had, you know, one of the MPs on the stage and they were, you know, had him participate in some kind of juggling trick or whatever, you know, and all that setting and platform and the seats and the whole pantomime show is really funded and by Shakespeare, right? That and everyone was cheering, you know, and the MP, you know, got popular. That is an election offence, right? And it was very much known back then, you know, following the 1688 Bill of Rights to be cheating. It was it's always been recognised to cheating because they're going to get an advantage over someone else who is standing, and it's not like just something that was, you know, put into the 1948 or 1949 Representation of the People Act. It's like it's been a long and well established in law, even before the people had the popular vote, even before the Great Reform Act in the 1830s, right? This is only when people with money could vote, right? They still didn't have their competitors, their opponents cheating, right? You know, if each of them has only got to spend a certain amount, which means that if you've got these, Knights of the Realm, and there's 8 of them standing for a seat, if one of them is getting, Shakespeare's, theatres, having him on there and getting him more popular, they're going to call him out on it, and they're going to say that he's cheating and not fair, right? Because it's not a fair competition. So it's not something which was just conjured up. More recently, with TV and radio, there's always been forms of entertainment and, people travelling around the country with shows and entertainers and so forth, and pamphlets and leaflets in the press and newspapers. So it's not new. And I think that even with social media now, right, if everyone's got a mobile phone and everyone's got a Facebook channel and everyone's got this, everyone, every town had some kind of stadium or theatre. Every town had a town hall. Every town had garden parties. At the end of the day, although it's easier now just to turn it on and record it, and the transmission's quicker, but people in towns, people in every village could have been, promoting or advertising Nigel Farage without him having to be there or without having to have a mobile phone, and that would have been considered as election cheating, right? The other candidates wouldn't have put up with it back then. So I think the mobile phone and it kind of it doesn't really matter too much whether or not, you just walk out of your house and there's a fairground there down the road and, some pubs with entertainment in. If they're all going to be promoting candidates and unfairly, and it's been funded privately, it's kind of cheating in a way. Well, it's cheating. So I don't think the mobile phone is too much. Now, how can you stop, loads of people promoting for or against candidates? It's very difficult. But I don't think that... I think the difference is that when it's a produced programme and it's studio TV and they've put a hell of a lot of money in to make the set look nice, and they've got makeup artists and they've got lighting and they've got a set and a studio and all that studio has been paid for and all that, that's when you're getting into, and then, I just happen to have a mobile phone and I can, film it, and, it didn't cost anything, It's like, I'll just film this and send it to all my 100,000 followers, right? Didn't cost anything, there's no money in it. But there is when there's that whole GB News studio with the Farage in the background with the name on it, and that's all privately funded. It wasn't put down on the election spending, right? So that's where the election cheating comes in, You could say, well, because... And the thing is, when someone has got 10,000 followers, not everyone has got 10,000 followers. So if you're using people's accounts, right, if Joe Rogan, right, has got, 11 million followers, right, that is an asset. Even not his studio. The fact, when you've got a company, right, when you've got a business, right, when you've got a business... When they evaluate the business, right, they don't just evaluate that you've got 15 pallets of widgets, a warehouse, 15 trucks, you've got, 300 staff, and you've got this stock. They evaluate, right, how many accounts have you got set up already? How many customer base have you got? Like you've got an established customer base, like you've got, if you've got 300 companies who deal with you on a regular basis, right, this is your established assets, right, and they're your regular customer base, which you have. That's evaluated as an asset, right? So when you evaluate the mobile phone, right, you might not have a studio or anything. Like Paul Thorpe, right? Paul Thorpe, right, he's just got his mobile phone. It's his account. You log into it, right? But he's got all these subscribers. He's got an audience. He's got, whatever thousands of people who watch him on a regular basis. Now, he didn't just get that for nothing. You can't just always buy that, right? That is an asset. Now, if you just give that asset to Nigel Farage and say, hey, Nigel, why don't you make a little video on my channel, right? It will go to my, 100,000 viewers, right? If Nigel Farage buys a mobile phone to use for his campaign, he has 0 subscribers, none, right? And all the subscribers which Reform collect and gather, they have, had to work and put that to them. If other people are giving Reform, donating them, hey, Reform, if you're Paul Thorpe, right, Joe Rogan, if Joe Rogan, right, gives his mobile phone to Nigel Farage and says, hey, Nigel, why don't you record your little, video with my mobile phone because I've got 11 million subscribers. That is an asset that he's giving to Reform UK or even Nigel Farage to increase his popularity, and it's not been accounted for. Even if Joe Rogan did not have a studio, even if he was in the middle of the fucking desert, right, and went onto his phone and logged in on his account, right, he has an asset which is, 11 million subscribers, right? Now, a lot of them might be in America, but a lot of them are probably in England, and some people are likely going to be in the area of which, Nigel Farage is standing for election, right? Southend-on-Sea, right? So that's actually an asset which has a value and capacity. It's almost kind of like having, a mail subscription system or something like that. So it's... And then I actually think that these political parties probably did some kind of scam with emails back under the Tony Blair government, when they were doing like email lists. I wouldn't have been surprised if Nigel Farage, not Nigel Farage, sorry. I wouldn't have been surprised if, Tony Blair and Gordon Brown and people like that would have, when they were in government, just might have, leaked some email lists from government into their political party. Oh, we'll have these email lists for our political party, right? I wouldn't have been surprised because that was the thing at that time, email lists, right? If you had those email lists now, you could do really well, like 38 Degrees do with their petitions. You could share petitions really easily. They've put a block on it now. Email lists are no use to you on Parliament Petitions website because unless you get it authorised, you can't get more than 20 signatures. They've locked it off. Until it's published, an email list is no good to you. And that's kind of like, I think, how Tony Blair wanted to nip that one in the bud earlier on with his number 10 Downing Street. Because they're never going to do you a favour, the government. They're never going to help you out to do something. I mean, you can always do it on paper. You can always walk around the village. You can always go to clubs and do it by hand. That's the old way of doing it. But the way to do it was in the newspapers, really, and get it in the newspapers and get people to sign it. And not a lot of people like giving their address out to send them to. Do you trust them to send them all into the Petitions Committee in Parliament and them all be accounted for? It's better if they send them to you and then you can count them all, right? But can you get a PO box number? Do you want your address in there? And now they're charging VAT illegally and hike the prices up, which is a major obstruction and illegal. So they're never going to help you. It's scam. It's complete scam and corruption. So, the newspapers themselves are embroiled in a very deep expenses scandal, the expenses of VAT and private advertising, definitely for petitions, because they've been illegally charging us VAT and putting the prices up ridiculously high. in many cases, you could put a free advertisement if it was lost property, or for a petition in a small local newspaper. They used to do it until they phased it out, and they started that, funerals, university graduations, and, weddings framework, which kind of like elbowed petitions out of there, set up a new rigid framework to keep things like petitions out for very affordable, extremely low budget advertising, in many cases free. I think that probably happened just late 80s to early 90s, but definitely by 2000 they got that into place. That was a strategic move by the newspapers when all the ownership got taken over as well. So there's a lot of things they've been doing, but the newspapers showed off about these MPs' expenses, and I haven't dealt with the Daily Telegraph, but the Trinity Mirror Press are pure evil. They really could not give a absolute fuck. Purely evil newspaper to the Trinity Press. They don't speak to the hand because the face ain't listening. They don't want to answer emails. They don't want to answer the telephone. They don't want to make a discussion. Like, big F you. Fuck you. A massive F fuck you, right? Fuck you. The London Evening Standard was a very, very nice newspaper. Really agreeable, even on the law, until we get into the matter of tax. And then they go funny because they don't like it. So unfortunately, they're just as bad as the rest when it comes to VAT. So that's the scandal. The newspapers' VAT expenses scandal for political causes while they're churning out Boris Johnson entertainment while he's Prime Minister. It couldn't be more scandalous. And now Jim Harris stepped down. I've telephoned a few MPs to see if they're going to ring these newspapers up and say something. James Murray, is it, the Exchequer Secretary, and the Secretary of State for Media and Sport, Digital Media and Sport, whether she's going to do anything or not, I don't know. They need to do something. So, they were laudable when it was the Lords, and now they are the centre of expenses. Who's going to tell the public about it? Do the public care now that there's, change.org, 38 degrees online? Parliament are obstructing quite a lot physically by just rejecting them on, when it's... You have the right to share it before you officially submit it, right? Completed. So I don't know, they're out of order of proceedings. So the newspapers really now are the expenses scandal central when it comes to political matters. And I think that they're probably... I think the newspapers and the TV... The TV... as far as I'm concerned, I didn't realise there were a problem until this Reform UK thing, but that was... The Reform UK is well over the line. It's just completely and totally completely gone. It's more illegal than illegal. In fact, it cannot be taken seriously or even entertained to be legal. So, and if the police don't prosecute, because these are all offences as well, you don't have to challenge the seats through election petition. All these are offences in law criminally as well, right? We've got the police chiefs now, because if the police chiefs do not prosecute Boris Johnson, do not prosecute Farage, do not prosecute these, it could even be Tracy Brabin, but she's the mayor. She's the replacement for the police commissioner. So Tracy Brabin is like replacing the police commissioner herself, who's assumed a position from Popular Entertainment, right? So this is why Keir Starmer won't act, because Tracy Brabin's one of his wing women, right? So how can Keir Starmer ever admit that in public? It's a shame on the nation, on his whole career, on himself. But this is a man of the law. I'm a man of the law, man of the law. He's a man of what? He's a pick-a-mix lawyer. he's like, oh, I'll have 3 strawberry chews, some false teeth, and a licorice also, but I don't fancy that. No, do you want to do this election law, Keir? Oh, no, I don't fancy that. I'll just have a couple of bonbons. He's a pick and mix, man, He's a pick and mix lawyer. He picks what law that he wants for his use. He's like a tool. He picks laws that are good for him to use to get his objectives, and the rest of the law he's got no care or concern for. In fact, it would be better if it didn't exist, right? So, and this is the thing with the police, they're not interested in the Public Meeting Act, and the police college is not really educating police properly. It's educating it's staff training and grooming to a regimed agenda, not to the full spectrum of the law. And then they've got all these policies. Oh, it's not policy, it's not police policy. Oh, it's not police policy to pursue election crimes. Oh, that's a coincidence. Wouldn't that be a concerted strategy? Wouldn't that be a concerted plan to be in on? Oh, let's have a police policy not to prosecute election crimes. And it's sad because reform are the only answer for a lot of people. To get Labour out and to oppose the Labour Party, now reform seems the only hope, right? And, I supported reform, but what's the point in just replacing a lot of corrupt politicians with more corrupt politicians? There's no point to it. And at the end of the day, the problem is corrupt politicians, not political parties, even if those political parties are pledging they're going to do something to the country which is more desirable and needs to put an immediate stop to what the current government's doing that people don't want it to do, right? It's just, more and more problems. You can't solve problems with more problems, So, these newspapers now are the scammers. The newspapers have been taking tax offers and demanding VAT numbers, tax numbers, when you're just putting a petition in and it's clear it's legit. Why wouldn't it be legit when it's addressed to the Parliament, right? So that's pretty much it.